Hello, everyone. Welcome to the webinar series on artificial intelligence and the rule of law. It is organized by UNESCO in partnership with the Inter-American Court of Human Rights, the National Judicial College in the United States, Lawyers Hub in Kenya, and the Center for Communication Governance at the National Law University in Delhi, India. I am Prateek Sipil. I am a program specialist, and I lead the work on AI and the rule of law at UNESCO. Some housekeeping before we start. So there is a button for interpretation at the bottom. It looks like a globe. So if you select that one, you can choose the preferred language, English or Spanish. We do have speakers in Spanish. So if you are going to be using English, please select the English one and not the floor. Then we will have Q&A at the end, and I would request you to also, while we are going through it, put your questions in the Q&A button at the bottom as well. So and I'll invite the speakers to respond to the questions that they find interesting, and we'll try to take more questions towards the end. And without further delay, I would now really like to welcome Assistant Director General Tawfiq Jalasi, who leads the work at the Communication and Information Sector of UNESCO, to give his opening words. Over to you, Tawfiq Jalasi.
Thank you very much, Prateek. Esteemed judges, distinguished guests, dear colleagues and friends. It is my great pleasure to launch the webinar series of UNESCO Judges Initiative, which is an integral part of our program on AI and the rule of law. Over the last decade, UNESCO has actively involved more than 25,000 judicial operators from over 150 countries in discussion on critical topics such as freedom of expression, access to information, safety of journalists, as well as AI and the rule of law. The recent emergence of generative AI has brought forth new challenges related to intellectual property rights, privacy, and data protection. As the judiciary stands on the front line of AI governance, it is entrusted with the task of applying existing and international laws and the human rights standards to address the ethical concerns and potential human rights implications arising from the use of artificial intelligence. Through these webinars, our goal is to shed light on timely and cutting-edge issues at the intersection of AI and the rule of law, thus ensuring that the integration of AI in the legal system aligns with the justice and fairness. We thank our partners, the National Judicial College in the United States, Lawyers Hub in Kenya, the Center for Communication Governance at the National Law University in Delhi, and the Inter-American Court of Human Rights. We thank them for their collaboration with UNESCO in co-organizing these insightful discussions. Today, we'll explore the fascinating intersection of generative AI and intellectual property, delving into the intricate legal aspects surrounding this topic. In June, we'll examine the admissibility of AI-generated evidence in legal proceedings, a subject of utmost importance in today's digital age. Lastly, in July, our focus will shift to the use of virtual reality and augmented reality technologies in courtrooms, a transformative development that holds vast potential. I would like to extend my sincere gratitude to all of you for participating in this vital conversation, and I eagerly look forward to the session. Now, I would like to invite the President of the Inter-American Court of Human Rights, Mr. Ricardo Perez, and my esteemed colleague, Mr. Ernesto Ottoni, UNESCO Assistant Director General for Culture, to introduce today's session on copyright and intellectual property. Thank you for your attention.
Thank you so much, Assistant Director Jalasi, for your opening words. I would now like to invite Assistant Director General for UNESCO's Culture Sector, Mr. Ernesto Ottoni, to share his opening remarks.
Thank you so much. So I will speak in Spanish, so you can put your... Bueno, muy bien. Excelencia, estimados participantes, estimados jueces. Es un placer acompañarlo hoy en la ocasión de este seminario en línea sobre la propiedad intelectual en la era de la inteligencia artificial generativa. Como saben, la innovación de la inteligencia artificial genera grandes cuestiones éticas en todos los ámbitos e incluye el sector cultural y creativo. Cada vez es más urgente dotar a todos los actores afectados de herramientas para garantizar que el desarrollo de la inteligencia artificial respete los derechos y libertades fundamentales. Con este fin, los Estados miembros de la UNESCO adoptaron en 2021, como lo mencionó mi querido amigo Tufik, la recomendación sobre la ética de la inteligencia artificial, el primer instrumento normativo mundial sobre este importante tema, que tiene como objetivo proteger la dignidad y los
ADG,
derechos humanos.
sorry to interrupt. I think we have a problem in the English channel. I just wanted to check with the technical operators if, yes, yes, now we can hear you. Yes. Sorry to interrupt, ADG. Oh, back to you.
But you want me to restart or I continue where I
No, I
was?
think you can pick it up from where you left.
Muy bien.
Yeah.
Entonces, como les decía, el año 2021, aquí en la UNESCO se adoptó la recomendación sobre la ética de la inteligencia artificial, que fue el primer instrumento normativo mundial sobre este importante tema. La declaración de la Conferencia Mundial de la UNESCO sobre Políticas Culturales y Desarrollo Sostenible, Mondiacult 2022, también reforzó el compromiso de más de 150 ministros de Cultura reunidos en la Ciudad de México en septiembre del año pasado, con la promoción, y digo, del respeto de los derechos culturales en todos los campos de la cultura, del patrimonio cultural, a los sectores culturales y creativos, incluyendo el entorno digital, para construir un mundo más justo y equitativo y de este modo reducir las desigualdades. Si bien la inteligencia artificial tiene el potencial de apoyar y acelerar el proceso creativo, así como de generar nuevas formas de creatividad, también puede apropiarse injustamente de la identidad y el trabajo de los artistas y amplificar las desigualdades. Las creaciones visuales o musicales generadas por este fenómeno en las últimas semanas demuestran su alcance y la urgencia de centrarse en el respeto de los derechos de la propiedad intelectual para que el desarrollo de esta inteligencia artificial generativa no opere en detrimento de la protección de los profesionales del sector, particularmente en lo relativo a la condición social y económica de los artistas y creadores y profesionales del sector cultural. El ejemplo del DJ David Guetta, que recientemente utilizó la inteligencia artificial para transmitir la voz de otro artista, Eminem, en uno de sus temas, pone de relieve la importancia de abordar de manera urgente la cuestión de los derechos de autor. También lo hace el usuario de TikTok, que creó una canción viral de Drake con The Weeknd, usando este sistema. La inteligencia artificial genera piezas musicales, obras de arte, relatos. ¿Estamos, y esa es la gran pregunta, ante un nuevo ente cultural? A medida que nos vamos adentrando en esta nueva era cultural digital, la comunidad internacional tiene la responsabilidad de hacer frente a los nuevos desafíos y proporcionar un marco que nos permita adaptarnos a los avances digitales, tales como la inteligencia artificial y otras tecnologías que llegarán muy prontamente. Fomentar el diálogo y la cooperación resulta crítico para proteger la propiedad intelectual en la era de la inteligencia artificial generativa. Con esto quisiera decir que es no solo un verdadero placer, pero una urgencia de tomar estos temas, conversarlos con especialistas, con entendidos, con la academia, dada la pertinencia de la temática y dada la urgencia de la temática. Es por eso que quiero agradecerle hoy día que tengan la amabilidad de juntarse a reflexionar sobre estos temas. Y queremos agradecerle en nombre de la UNESCO con mi compañero Tufik por la participación que hoy día están teniendo con nosotros. Muchas gracias y que sean muy fructíferas las conversaciones en este seminario.
Thank you, ADG. Thank you, ADG, for setting the stage. Just as a reminder for participants, you can select the language, the preferred language, by clicking at the globe at the bottom and then choosing the correct channel. So we have the whole webinar available in English and Spanish. Now, I would like to invite, he would have joined us in person, but he has a court proceeding going on, the president of the Inter-American Court of Human Rights, Mr. Judge Ricardo Perez Manrique. He has shared a short message with us. So I would request the online moderator to share the message with us, please.
Estimado Taufik Gerasi, Director General Asistente de Comunicación e Información de UNESCO. Estimado Ernesto Otone, Director General Asistente de Cultura de UNESCO. Señoras y señores, desde la Corte Interamericana de Derechos Humanos destaco la realización de este ciclo de webinars dirigidos a operadores judiciales sobre la inteligencia artificial desde un enfoque de derechos humanos. Celebramos la realización de este ciclo en alianza con UNESCO desde nuestro Centro de Formación de la Corte Interamericana de Derechos Humanos. Este seminario web es parte de una serie de seminarios web de la UNESCO para operadores judiciales como parte de su programa de inteligencia artificial y su vinculación con el Estado democrático de derecho. Saludo a los coorganizadores de este programa, Colegio Judicial Nacional Estados Unidos de América, al Centro de Abogados Kenia, al Centro para la Gobernanza de la Comunicación, a la Universidad Nacional de Derecho de Delhi en India. La inteligencia artificial puede tener muchos beneficios que podemos ver en nuestra vida cotidiana y especialmente vinculados a mejorar la calidad de vida y el desarrollo sostenible. Por mencionar solo algunos, por ejemplo, esperar menos por el transporte público, permitir el acceso a atención en salud a personas que están lejos de centros urbanos, identificar estrategias para adaptarnos mejor al cambio climático, incrementar la producción de alimentos más sanos, diseñar edificios que sean más eficientes en su energía. Pero esta inteligencia artificial significa, como señalan algunos pensadores de este tema, que por primera vez el ser humano ha creado la posibilidad de una inteligencia alternativa a la propia inteligencia humana y que esto implica una serie de riesgos y una serie de dificultades que son imprescindibles tener en cuenta en perspectiva de derechos humanos para avanzar en el trabajo tecnológico y para avanzar en todas las garantías que debe haber a ese desarrollo tecnológico. Como en todos los campos de la vida humana, si no se gestiona este avance a favor de la humanidad, ello puede conducir a resultados injustos y violatorios de los derechos humanos. Sin supervisión humana, sin el control humano, estos cambios pueden ampliar las desigualdades económicas, sociales y culturales y pueden convertirse en sí mismo en un escenario propicio a la violación de los derechos. Y ahí la importancia de estos ciclos de formación. Es necesario que las herramientas tecnológicas no sean las nuevas causantes de más desigualdad entre quienes menos tienen en el mundo, o de nuevas formas de desigualdad hasta ahora desconocidas. Esta nueva realidad nos invita a todos los operadores de justicia a estar formados e informados, y por ello la importancia de este ciclo de formación y a no estar ajenos a este debate tan profundo que se da hoy en el mundo sobre esta temática. Debemos interrogarnos respecto a por qué ciertas personas han sido catalogadas por la inteligencia artificial como más propensas a cometer delitos en virtud de los algoritmos que determinan esta inteligencia artificial, en función de que tienen sesgos en torno a personas afrodescendientes o latinas. Preguntarse sobre las implicancias legales de los sistemas de reconocimiento facial que se alimentan de preconceptos estereotipados ¿Quién regula los procesos de cibervigilancia? Son solo algunas de las preguntas vinculadas al impacto de la inteligencia artificial en la administración de justicia. Mientras se avanza en el debate sobre la regulación, es necesario ir debatiendo sobre la ética de la aplicación de la inteligencia artificial. La recomendación sobre la ética de la inteligencia artificial aprobada por UNESCO es un paso adelante y de referencia a nivel global. Este documento establece un estándar global para la inteligencia artificial que se basa en valores y principios éticos. Además, ofrece orientación detallada sobre cómo aplicarlos en una amplia gama de áreas que están siendo impactadas por la inteligencia artificial, como la gobernanza de datos, el medio ambiente, la igualdad de género, la economía y el trabajo, la cultura, la educación y la investigación. Celebro la realización de este curso, así como otras instancias dirigidas para operadores de justicia en las que participaremos con UNESCO desde el Centro de Formación de la Corte Interamericana de Derechos Humanos. Capacitarse y capacitar es el camino para que podamos conducir la inteligencia artificial con un enfoque que la sitúe en, por y para el respeto de los derechos humanos y del ser humano, nunca dejando de perder de vista que la dignidad del ser humano es el centro del trabajo y el centro por el cual los derechos humanos tienen razón de ser. Muchas gracias.
Thank you. So that was Judge Ricardo Perez, who was the president of the Inter-American Court on Human Rights. Now, I would like to hand over the floor to the moderator for our panel discussion, Dr. Miriam Stankovic, who is a principal digital policy specialist and works on intellectual property rights issues to take us forward in the discussion. Over to you, Miriam.
Thank you, Pratik. Today with us, we have a star-studded panel of experts. We have our keynote speaker, Ms. Soo-Wen Chung. She's an artist and a researcher, and she's the founder and artistic director of Silicet, a London-based studio exploring human and non-human collaboration. Ms. Chung is a former research fellow at MIT's Media Lab and is considered a pioneer in human-machine collaboration, exploring the mark made by hand and the mark made by machine as an approach to understanding the dynamics of humans and systems. Next, we will have Dr. Marielza Oliveira. She serves as the director of the Division for Digital Inclusion and Policies and Digital Transformation at UNESCO. Prior to this role, Dr. Oliveira was a director of UNESCO Beijing, covering 5 East Asian countries. She was also the Global Results Manager for UNDP and held positions as a country manager for a portfolio of Latin American countries. Mr. Neil Turkovits is the president of Turkovits Consulting Group. He is a copyright activist and member of the Artists' Rights Alliance and Music Workers Alliance. He served as EVP International at the Recording Industry Association of America and is a former member of the board of the Chamber of Commerce Global Intellectual Property Center. He is a passionate defender of the arts and of sustaining cultural workers through their craft and an active participant in public discussions of AI and art. We do have also Liz Lenjo. She is the founder and managing consultant of My IP Legal Studio. She specializes in intellectual property, entertainment, media, and fashion law. She has been appointed as the chairperson of the Copyright Tribunal of Kenya. And she is also a member of the International Trademark Association and serves as a member of the Global Advisory Council Africa. And last but not least, we have Professor Dr. Thomas Margoni. He is a research professor of intellectual property law at the Faculty of Law and Criminology, KU Leuven, and a member of the board of directors at the Center for IT and IP Law. His research concentrates on the relationship between law, data, and technology, and he has been focusing on the changes in the creation, access, transformation, and distribution of knowledge and information brought by technologies such as the internet and artificial intelligence. And now, Ms. Chung will deliver her keynote on an artist's perspective on human-machine partnerships. Ms. Chung, the floor is yours. Please take it away.
Thank you so much. Just going to share my screen here. This one, let's see. That work? 1 second. Okay. So good morning. It's such an honor to be here with you. My name is Sue Gwen. I'm an artist and researcher exploring human and machine collaboration. In my work as an artist and researcher, I thought of machines and the technologies that drive them as perfect neutral tools that could make my work more efficient and productive. We've seen industries increasingly automate human work with machines, and it led me to wonder if machines are starting to be able to do the work traditionally done by humans, what will become of the human hand? How does the drive towards perfection, precision, and automation affect our ability to be creative? So for the past decade, I've been exploring AI and robotics to develop new processes for human creativity. I've been creating art alongside machines, data, and emerging technologies. It's part of a lifelong fascination with the dynamics of individuals and systems and all the messiness that entails. My interest in working with robotics came from the practice of drawing. Working with robotics and drawing brings me back to the body, the mark made by hand, and what things like muscle memory and the physical instinct can inform about the creative process, how they can evolve and expand. So this work has taught me a few things. It's taught me what embracing imperfection can teach us about ourselves, and more importantly, that the simulation is not reality. It's taught me how art can actually help shape the technology that shapes us. It's taught me how combining AI and robotics with traditional forms of creativity, visual arts in my case, allows us to think a little bit more deeply about what is human versus what is the machine. And it's led to the realization that collaboration is a key to creating the space for both as we move forward. It's a space in which cultural critique, poetics, and practice can define new landscapes in philosophy, technology, engineering, and design. To evoke a metaphor, it's as if two sets of eyes take in the same scene. The same light passes through two different apertures that see completely different things. One set of eyes is muscle and nerve, evolved over millions of years, unique in the universe perhaps, but better understood with each passing day. One set of eyes is metal and plastic, engineered for the tasks at hand, uniformly constructed, yet growing in complexity at a rate we may not be prepared for. One is biological and the other is mechanical. And in a sense, they collide. This collision might seem extraordinary, and it is, and it's also the basic condition of our lives today. The truth is we're seeing double. It's the double view of machine vision and the view through security cameras, satellites, and social media. We've constructed a world where all sight is dual sight, and all sight is seeing, and all seeing is a bridge between the contradictions of nature and machine, of art and of engineering, and of self and the collective. It's true, the rate of technological advancement is accelerating. The machine's role in society is evolving. The questions raised by AI systems, robotics, and technology can point to a bleak future. They make us ask questions about whether machines will replace workers and whether machines will replace artists too. It's hard to look at a headline today without feeling one's anxiety stir. Will we be replaced? Will we replace ourselves? Or will the machines somehow save us through technological advancement? Will they liberate us from want, fulfill our desires, and keep us safe and healthy in a way nature never could? Will they offer us a way to transcend our evolution? This duality, this promise of anxiety of its consequences shapes my worldview. I would go so far as to say it shapes us all, really. My work at its simplest level is about exploring the contradictions that stem from duality, exploring how those contradictions point at a third path, and what I like to think of as a new hybridity. It's a space I feel at home at. It might be because I'm a product of two cultures myself, of two languages. And as a child of a musician and a computer programmer with a fascination with science and art, I think that's why I've spent the past decade combining oldest forms of art with new forms so advanced we actually need to invent the technology as we go. It's no secret that I and you and everyone we know is a participant in these contradictions as well. Working with AI and computation is a way to expand what art is and what art can be. Art as cognitive science, exploring alternative forms of consciousness. Art as engineering, constructing robotic systems for empathy and connection. Art as philosophy, imagining new social and moral constructions for this human-machine relationship. At the intersection of these fields, my team and I create simulations, performances, and artifacts across scales. We work in the large scale, like this relational robotic performance, integrating satellite and biofeedback, and in the small scale, like these prototypes for robotic units inspired by the microscopic threads that link fungi into a biological network. We looked for that intersection, that gray area between human and machine, and we stumbled upon it in the first piece in a series called Drawing Operations. Drawing Operations Unit Generation 1, which I call DUG for short, was about seeing, which is the first step towards knowledge, because to know the world, we must first observe the world. It worked through computer vision and a robotic arm. We started by taking one of the most visible frequencies in the color spectrum, red, and deploying it for our first collaboration. We thought if we could utilize the machine system's reductive functionality, its ability to be selectively colorblind, we could communicate drawn gestures to a robotic unit in real time. By creating a gestural balance between human and machine, I thought about what my colleague Sepp Kamvar calls self-reinforcing technologies versus self-limiting technologies. In his scheme, self-reinforcing technologies kickstart an established human process, like, say, drawing, while self-limited technologies replace a human process, like a robot on an assembly line. I aim to break this dichotomy, to build a technology that doesn't encourage more of the same or reduce through replacement, that doesn't atrophy physical processes in service of computational ones, a technology that creates something new as it's being used. After exploring the duality of sight, of computer vision versus the human eye, we were inspired to explore the next generation of drawing operations. We moved from sight to the record and recollection of sight. We were inspired by memory. We looked for the possibility of approaching machines beyond pushing physical parameters to its limits. To do that, we needed to draw from a larger data set and construct a framework for machine interpretation. So, like human memory, we looked at 2 decades of my own drawings as a kind of data set. It was like embedding a record of my own memories into the artwork. We trained a recurrent neural network on these 2 decades of drawings and produced an AI system rooted in the analog and given new life in the digital. Memory and acting on memory created a collaborative partner in DUG2. This revealed the possibility of using machines as collaborators, not as tools. Now I'm not in control and I'm working with it towards a common or possibly unexpected outcome. We're being told that the purpose of art and AI is to automate the process of making, and I disagree. Instead, I'm adapting my artistic gestural memory through working with algorithmic prediction rather than being replaced by them. Automating my work is not a target of the AI system. It could be said that the art is the approach to co-creation to manifest this third thing. It points the way towards relational interactions that offer new forms of knowledge production in action, art practice as research, and art practice as interdependence, not codependence. With my third drawing operations piece, I thought about the gaze of the machine and began to see vision as multidimensional, as views from somewhere. We collected video from publicly available camera feeds on the internet of people walking on sidewalks, cars and taxis on the road, all types of movement. We wrote a vision algorithm based on a technique called optical flow to analyze collective density, direction, velocity, and dwell states of urban movement. Instead of a collaboration of one-to-one, we created a collaboration of many to many. By combining the vision of human and machine with the city, we reimagined what a landscape painting could be. So I've said that perhaps the future of creativity isn't in what it makes, but how it explores new ways of making. What would happen if we continued to challenge our idea of what intelligence actually is and what these configurations with technology can be? This is our future, and in many ways it's our present. To me, this is our emerging relation between human and machine. This, for me, is the third way, the hybrid where human intelligences and the unique agency of machines collaborate. This is my bridge between the contradictions, and I'm excited for the beautiful and unknown wonders that will emerge from it. Thanks so much for listening.
Thank you, Ms. Chang. This was fascinating, and this serves as a nice introduction into the topic that we are going to discuss today, that is generative AI and intellectual property. And I would start with Dr. Oliveira. Could you please tell us what artificial intelligence is and what generative AI is in particular? How is generative AI a game changer, if any, with its memory capacity? Please, Dr. Oliveira, take it away.
Oh, thank you very much, everyone, and thanks for giving me the floor. And oh my God, now I have to follow this beautiful artistic presentation with a technical one, very dry. But so let me go ahead and try. Well, first slide, please. Let's start with the absolute basics on what is artificial intelligence. Essentially computer systems that copy human cognitive abilities and while taking or making decisions. And machine learning is a type of AI that learns how to improve its own performance over time. It learns differently depending on what kind of data is available. And there are different types of data. For example, for supervised learning, we must have labels, which in turn means that we must know in advance what categories exist in the data set and feed the computer millions of examples from which it can actually learn to recognize each of those categories. The earliest ones were actually spam filters that classified emails into like junk or legit emails by applying patterns found in previous junk and legitimate emails. For example, if subject equals good deal for you, then classify email as junk. Supervised learning requires human support to learn and task experts for defining categories and annotators to label data. So it's a beautiful representation, for example, of this third way of a combination. Unsupervised learning is different. An algorithm actually applies cluster and segmentation techniques to unlabeled data, to find patterns that can be used then to classify new data. Like when a group new emails together with other good for you, emails, then it ends up in the junk folder. But we also have, a mixed data. We can use semi-supervised learning. But then there's this new thing called reinforcement learning, in which an algorithm actually learns by receiving feedback from a human or from another algorithm in the form of a reward for good performance. It refines its method then so as to maximize the total rewards that it receives. Next slide, please. Okay. Well, deep learning then is machine learning that is inspired by the human brain. How beautiful that is. Huh? These algorithms that are called neural networks learn by example, but they need billions of examples to create the many, many filtering layers that they use to produce a result. In this slide, for example, we see a neural net that is learning to identify human faces in pictures. In each layer, they classify a group of pixels as representing an important feature and pass that information to the next layer. You're going from background versus target image, then face versus not face, then human versus animal face, until they can actually say, yes, a human face was detected. Next slide, please. Generative AI is a type of neural net that is able to identify patterns and structures within a data set, and upon request or our prompt, generate an output that is kind of a remix of its training data. It's pre-trained on gigantic data sets using super powerful computers and lead to a foundation model, which is a highly flexible model that can perform a wide variety of tasks and which then must be fine-tuned or adapted to perform to a specific task. Next slide, please. There are basically two types of generative AI that everybody's been talking about these days. Foundation models that process, process images, and those that process text. And there are different recipes for creating these types of models. Image processing, for example. The face recognition example I gave before was what we call a convolutional neural network, which learns by passing image through layers and filters. In each successive layer, it identifies different features, and then the model learns to identify the entire object. We also have something called diffusion models, on the other hand, that work by adding noise to an image until it's no longer recognizable. It's kind of dissolves it. Then it learns to reverse this process and reconstruct the original image by mixing it with other images when prompted to do so. You know, most of these image generating software that we have out there, DALL-E, Midjourney, Stable Diffusion, etc., are these examples of image generating AI. And we have language processing, natural language processing models that kind of calculate the probability of a certain word following a previous one across this billions and billions of words that it has in its data set, and pays attention to both the frequency with a word, which a word follows another, and to its position. So it actually learns context. So paying attention to context is important in text, for example, because when they see the word chair, it speeds up the processing of differentiating between chair, like example, as a piece of furniture, and chair as a person leading a committee. And that makes the model faster and better at generating the kinds of words that follow when the prompt word includes chair. Next slide, please. So a large language model are essentially a foundational model designed to perform language tasks. They are pre-trained on huge text corpus and then fine-tuned to do something specific, such as converse with users like chatbots, or generate software code, labels for images, summarize text, or identify if product reviews contain positive or negative sentiments, and so on. But what is fantastic about them is that they are really incredibly flexible, and new ones are appearing every day. Powerful ones are already available, such as the OpenAI's generative pre-trained transformer series, the GPTs, the Meta AI large language model called Llama, Google's Lambda, Palm, and Bloom, that was actually the result of an international consortium of over 1,000 AI researchers collaborating to create it. And new applications and new users are appearing almost daily. So if we blink, we miss it. But you know, they have their issues as well. So let me stop here.
Thank you for sharing these insights. Now, as we witness the remarkable capabilities of generative AI models like ChatGPT, DALL-E 2, and Midjourney, among others, and these models create a wide range of content with remarkable ease and speed, it begs the question, how does these emerging technologies impact intellectual property?
Oh, well, that is a fabulous question. So let me see, hold on for a second. Can you put the slides again on the screen? Who is running the slides? Thank you. We'll take from the slide 7, please. It's easier to show. Nope, one right before, yeah, one before that. Intellectual effort. Slide 7, please. Where is it? Yes. Okay, great. Thank you. Well, I mean, let me just say that generative AI and IP are intrinsically linked. And because AI, really, all these systems, they cannot exist without tremendous intellectual effort having been made by a lot of people all the way. Those who produce the individual pieces of data that end up in the data set, the big data architects that organize this data set, machine learning engineers that create the algorithms, user interface designers, and even the users themselves. So next slide, please. But the critical thing is that data is the most important ingredient in generative AI because it's used for both training and for validation of a foundational model, 2 different data sets for that, and then another one for fine-tuning an application. And raw data is collected from online sources. It actually is born, most of it, as human expression. Individual pieces can be a tweet, like a news article, a picture that is posted in social media, and they have an author who may or may not have been, have actually given informed, meaningful consent to have that expression collected for the purpose of training a generative AI. And current approaches that we know about that, that for gaining user consent raise a lot of ethical questions, but that's not the point of the topic today. But then we have data augmentation, which is also used to generate additional data, but from the individual pieces of data that we already have. We can feed batches of images into a software that creates new images by like zooming, cropping, flipping, etc. Text is actually done slightly different because it's back translation or synonym replacement. Like you have the phrase, "This is super cool." Then so you can augment the text by saying, "This is very cool." Because while the upside down image of for example, a Picasso is still the image of a Picasso, when you shuffle words around, you change the meaning. This is good, for example, does not mean the same as is this good. So augmentation actually exists to improve data sets from the side of quantitatively adding more pieces, but more importantly, they exist to change the quality of the data set by enabling a model to identify a kind of, like example, a type of animal, a bird, in different poses and contexts under different lightings, which reduces the problems of training the model and also potentially help to mitigate biases because it helps to augment certain types of categories. But augmented data actually are altered copies of existing individual pieces of data. So we must go back to thinking about authorship and consent. And then finally, we have synthetic data generated by feeding like a subset of the available data into an algorithm that then learns patterns, like human faces have 2 eyes and a nose, then generates new individual pieces that actually display the same pattern. So it creates pieces from groups of individual pieces that we have, not from individual ones. So it's important, for example, in protecting privacy, so that a system doesn't quite spit out an actual face by accident. But overall, the important thing is that this data is coming from humans, and whether or not we subsequently do something with it, it's human expression in this way. So next slide, please. And AI developers can also buy existing data sets. A big famous one is Common Crawl Corpus. It's so hard to say. It contains data grabbed from 15.7 million websites and more. And in the Google C4, with the colossal clean crawled corpus, which is actually a cleaned up version of the Common Crawl with other stuff added. And, so when you look at this, you scrutinize these data sets, the copyright symbol appears 200 million times. It contains all of Wikipedia, every patent in the US register, news media from all over the world, pirated ebooks, and a lot more that raises concerns around intellectual property and other concerns too. No, so next slide, please. But a lot needs to be done to act the actual raw data that is scraped from the internet before it can be used to train a model. It needs to be standardized, normalized, the duplications deleted, filter altered toxic and illegal content, threats and stuff. And the resulting clean data set will then be broken into pieces, like it's called tokenizing it. With pieces called words, sentences, etc., to use to create a kind of a dictionary for the neural net to read. The models will learn the relationship between tokens, not between the raw data pieces, and are trained to generate the next token in a sequence. So that also changes, issues around, property, because it's not taking the original data set necessarily, but this token data set. It depends on how different systems will see it differently. So next slide, please. And finally, you also have a language model, that's once it's trained and fine-tuned, for example, it's a chatbot, it can answer requests from users. So there's this kind of new type of IP coming up, which is the set of instructions that called the prompt that users pass to a generative AI application requesting it to perform a specific task. It's kind of how you program a generative AI. And There's even an emerging profession called prompt engineer, in which an expert in the techniques to guide the language model towards producing a desired output, exists. And good prompts are actually valuable. And there are several websites around the world selling packages of ready-made prompts that people can use. So next slide. And outputs also, finally, the last one, can be monetized, as well. But, and there are many IP and other implications, art implications out of outputs of machines. But I want to highlight 4 points from the technical point of view only. First, terms of service of most generative AI apps request consent to collect prompt and output pairs, which are then used to refine the model. So then, again, you get that authorship issue, but now mixed with the authorship of the human as well. Then you have the second issue, which is the output may not even be the result of a user's prompt if there was what's called prompt injection, which is happens when somebody hijacks the original prompt on the way to the server, changes the instructions, and then something unexpected comes out. And then a third issue is that users may trick an artificial intelligence into regurgitating confidential or sensitive information held in the data set. You have Samsung, Apple, and several other companies that have either suspended or banned the use of chatbots because of bad experiences with proprietary software code that was included in the output of a coding prompt. And then just the last point is that, which is interesting, is that large language models generate text outputs whether or not they have sufficient data. We call that misinformation, and the AI developers call that hallucinations. It's interesting that in the image processing world, those that are decried in the language world are actually prized for being unexpected, for being something that nobody had requested and appeared on its own in a way. So let me stop here, and because there's quite a lot already, and we can talk more during the Q&A. Thank you very much for attention.
Thank you so much, Marielza. This was fascinating and super interesting. And we turn to Neil now. Now, Neil, generative AI can seem like magic, okay? So image generators can produce remarkable visuals in styles from aged photographs and watercolors to pencil drawings. These resulting products can be fascinating. Quality and creation speed are elevated to average human in comparison to average human performance. Then we have also text generators that are even whose capabilities are even more striking. They write essays, poems, and text summaries. Well, it may seem like these new AI tools can conjure new material from the ether. That's not quite the case, as Marielza already pointed out, because generative AI platforms are trained on data lakes and questions and constructed by software processing, vast archives of image and text. And the AI platforms recover patterns and relationships, which they then can use to create rules and make judgments and predictions when responding to a prompt. Now, this process comes with legal risks, including intellectual property risks. And these generative AI-powered applications create copyright challenges regarding plagiarism, content creation, use of content, publication and enforcement, and infringement liability. Now, Neil, could you please explain how generative AI impacts the copyright system and how are traditional copyright laws challenged with systems such as DALL-E 2, Midjourney, and ChatGPT-4? Neil, take it away, please.
Great. Well, first of all, thank you very much for inviting me to participate in this. Sort of interesting. I love that I'm coming after Suguen and from Marielza, because each of them have explored something that's critical, I think, to the understanding and to really what I want to say. First, with Marielza having expressed the fact that generative AI and AI even more generally doesn't exist in the absence of outputs of the inputs, and those inputs are human generated. So we have a fundamental question about how we want to govern the relationship between human output and machine ultimate production of artificial intelligence. Sogwen, I thought, had a beautiful opening in which she described, I think very passionately, very accurately, the capacity of AI to assist in the creative process. And I think it illustrates one of the central misunderstandings of a lot of the artist movement concerned about AI. Artists don't view AI as only being a challenge. There are the challenging aspects, but as a potential partner in the creative process and continuing to challenge questions about what is the meaning of art? What is the meaning of art in society? All of these things welcome new challenges, and technology has always been a part of how art has re-examined itself, has explored itself, and has recreated itself in new images. So I just want to start off by expressing my appreciation to the two previous speakers who have done a fantastic job of laying out some of the foundation. I'll also note that even though I am a lawyer, and I've been a lawyer for quite a while, my thought process in looking at generative AI and the relationship to the arts is motivated more by my general sense that we're defining the rules for a digital society. We're defining the rules and the scope of agency and the role of consent in a digital environment that increasingly puts pressure on the ability of individuals and communities to define their own futures. So I think, to me, that's the overriding question when examining all of the issues related to AI, and particularly generative AI, so that we don't end up going down simply legal rabbit holes of what is the nature of the application of existing rules, both at the national level and international level, in respect of AI. I mean, I do engage in those conversations. I have particular views. I do think that the unauthorized use of existing human creations to train AI is a fundamental violation of the right of authors and creators to control the uses of their works. That right to control uses is found in national laws throughout the world. It's found in international treaties, and it's founded in international human rights conventions. So we do have this fundamental conflict between this desire to innovate by using existing materials and the existing infrastructure. Having said that, there are certainly some novel challenges that get presented by AI in the creation of new works based on existing works. And they are admittedly complicated, both legally and conceptually. One of the things that anyone who looks at this space sees constantly is kind of this sense that, well, haven't artists always relied on the existing corpus of cultural output in order to create new works? And that's viewed by defenders of current, what I view as inequitable AI models, as sort of this perfect defense, that this is just more of the same. And this is one area where I think those claims simply don't hold up at all, and where I wish well-meaning people who offer those, and there are well-meaning people, and also non-well-meaning people who talk about that. There's a profound gulf between an individual being inspired by the works around her in the development of her new work, compared to the corporate ingestion of the existing cultural output of human creators in order to train a commercial product that very well may pose an existential challenge to the work of the cultural community. So we have to bear that in mind. We have to bear in mind the underlying differences and the underlying negotiating asymmetries between artists and companies versus artists and other artists. So turning to the law, and again, I view the law in many respects as the least interesting part. I do think that the ingestion of existing materials, it does violate national and international law. You have to look at this from a country by country or region by region examination. In the EU, the 2019 Digital Single Market Initiative did highlight specific terms for text and data mining for the production of AI. Under Article 3, there's a relatively broad exception for research organizations, and there's a much more confined one with respect to commercial establishments, in which one of the foundational elements is there has to be a practical way to opt out of inclusion of your works. That opt-out is not currently in place in any of the major models. So that I think from a European perspective, all of the existing models, generative AI models, violate the terms of the 2019 DSM. In the United States, it's a little more complicated. We don't have statutory exceptions for text and data mining for the purpose of training AI. And instead, we have the application of fair use. Fair use is very fact dependent. It's a fool's errand to ever predict how a court is going to rule on fair use. But my general sense is it should not fall under fair use. I think it fails to meet all of the three major conditions established under international law. It doesn't apply. It's not a special case. It does conflict with the normal exploitation of the work. And I think it does unreasonably prejudice the legitimate interests of the creator. So I think from an international legal framework, you have a very strong argument that fair use should not and cannot, consistent with international law, allow for the mass ingestion of creative works for the purposes of training AI. I think that's an overall framework. I don't know where I am on time, so I'll
very briefly, yes,
rest.
because we are kind of running out of time. So
Yeah.
These generative AI models, they use data lakes with thousands or even millions of possibly unlicensed works, right? So can you please highlight the key challenges very briefly? I know it's a complicated question around data ownership and control in the era of generative AI. So there have been discussions in for example, at WIPO, where countries are discussing different models of data ownership, whether whether we need a new data rights in respect to generative AI, and what's the impact of generative AI on how copyrights interacts with data and data ownership. Over to you.
Yeah. So again, I don't believe that we need new rights with respect in order to address the question of the unauthorized ingestion of creative materials. I think the Berne Convention, the WIPO Internet Treaties, national laws, and European directives establish a framework for that would give artists the ability to prevent such ingestion. I do think we have perhaps complicated, in a sense, ensuring that consent is the basis for movement is only the first part of the equation. We then get into what I view as a much more difficult issue, which is how is that consent going to be manifested? And that is one area where I think we need to explore the role of collective management, the role of other things to ensure that simply establishing a right or enforcing a right doesn't then fail to achieve our broader social objective, which is to give artists a meaningful ability to prevent that right and to license it on terms that will sustain creativity. The final thing I would say on that is I think sometimes people view this as a parochial thing. Should we do this for artists? To me, this is not parochial. To me, this is about us as members of society wanting to sustain creators and the things that make life meaningful. So when I approach this, yes, I have huge empathy for the creative community, but I'm not just doing it for the creative community. I'm doing it for everyone for whom music and art and poetry give meaning to life. And I think, again, that's kind of my overriding objective throughout all of this.
Thank you. And these remarks and these insights serve as a nice introduction into, my next question, which is for Liz. So Liz, could you please walk us through the unique challenges and opportunities faced by the Global South in generative AI with respect to IP laws, particularly regarding access to and protection of traditional knowledge, cultural expressions, and indigenous innovations? So how is generative AI a game changer in this regard, if at all? Please take it away.
Thank you. Thank you for that question. I'm honored to be here and to just share some of my thoughts and observations. I really love what the previous speakers have spoken about, the issue of AI being more of a partner, a collaborator. I think that really opens up the minds in terms of the opportunities. More, instead of having the conversations around AI replacing us and our work, it's about collaboration, which is pretty awesome. And that leads to the answer: what kind of opportunities are there in terms of traditional knowledge, cultural expressions, and indigenous innovations? Just going back a bit, the greatest challenge right now with the TK system is the fact that there is still a lack of knowledge in terms of communities. And, unfortunately, giving an example of Kenya, we already have a TK Act, right? But you see that the communities are very heavily reliant on government. So that makes the process of protecting TK and TCEs almost a government intervention situation. And I think we really need to shift the power to the communities. So we really need to figure out how we empower these communities so that then they can do it independently, especially in light of, say, change of government, right? There's a stagnation there that we have faced in terms of that. So we're trying to get communities to understand the issue of documentation, and AI would come really as a very good partner and a collaboration asset, because most communities are just struggling with the issue of resource mobilization, and even once they document, where are they going to put this TK and TCEs, right? How are they going to assert these rights? So the issue of AI, I think, is something that communities would benefit from. And educating most of the communities in the Global South would be really important. The issue of access to technology, the issue of access to education in the technology space would be a really big game changer. I think also looking at educational institutes, again, institutions in the Global South, figuring, collaborations with tech companies, with, supporting partners that can help them understand AI more, right? Because we are seeing a lot of misinformation around AI also coming from academic institutions because of that lack of understanding. So I think that would bring a lot of, it would shed some light and help fuse AI and technology into the TK and TCE space. I think it would also help with ease in access to TK and TCE once AI is asserted as a partner, because then it means that if there is a third party interested to either license a TK or a TCE, or either there's even a community member who wants to reinvent something or create a new innovation or improve something, then they're able to get access. They're able to also figure out permissions, the issue of consent. Again, when communities are better trained, it will even be easy for them to be, to be reached, right? Because the issue has also been, where do I go? Who do I go to? How do I do that? And I think with AI, communities could actually create, quote unquote, a home that is in the digital space, and you're able to say, community X, this is their database, this is how I can reach them and whatnot. So that ease of access, right? And then, of course, AI would give the ability to monitor the use of TK and TCEs as well, because again, that has been an issue. Monitoring has been really a challenge, and having it in the AI and also setting up those algorithms to help monitor and police would really be effective, right? So that then even it would also act as a deterrent in terms of respecting TK and TCEs and asserting these rights, I think it would be a great, partner. And then the other thing would be AI can help to be proactive to ensure monetization and payment without necessarily needing to come to Kenya, for example, right? I think in that regard, AI would really facilitate more collaborations and build a stronger TK system, in my view. So we have a lot of room for growth, definitely. We still have a lot of room for understanding, knowledge exchange, and to train more of the communities and community leaders. Because again, sometimes, when you think about educating a community, it can be a really massive headache. You wonder, where do you start? And I think when you identify the leaders and people who are passionate about the TK and TCE system, when you start with them, then it's much easier to help them mobilize communities and to help them also speak more to their communities and figure out how they can advance TK and TCE rights. Yeah, thank you.
Thank you so much, Lisa, for giving an overview of how generative AI can impact access to and sharing of traditional knowledge in developing countries. Now we will segue into a more specific and technical discussion. So, and I'm talking to you, Thomas. So how will judicial operators address IP-based challenges posed by generative AI systems? For example, in a class action comprised of at least thousands of other creators, Midjourney, Stability AI are being sued for copyright infringement, violations of publicity rights, and unfair competition. Getty Images has also filed suit against Stability AI in the US and separately in the United Kingdom based on Stability AI's alleged use of more than 12 million images from Getty's database for machine learning purposes. So how are judicial operators going to approach this conundrum? Thomas, the floor is yours. Please take it away.
Thank you, Miriam. Even though I'm not sure I should thank you for such a question. I think this is one of the challenges that the judiciary will need to face. I think that there are elements in the interventions by each of the previous speakers that point in the right direction. There is an element of technical and technological complexity that, among others, Maria Elisa pointed out. Judges, of course, will not be asked necessarily to understand that level of complexity, but certainly familiarizing to a certain degree with the processes of learning that machine learning and other forms of modern artificial intelligence applications employ will be a first necessary step. But that, of course, is not sufficient, because then they will need to qualify legally the different steps. Not everything that happens is necessarily a copyright infringing activity. Others may certainly be, but then the question here really becomes one of categorizing legally first and foremost the area that we are discussing and how and in which sector are we really applying this broader conversation. I mean by that I've heard in the previous interventions very compelling arguments regarding the impact that generative AI could have on the creative sector, and those are obviously evident to most, but also in terms of, for example, disinformation and deepfakes. This is a first element that a court or a judge asked to address an issue would need to correctly categorize, because of course, if our goal is to adjudicate a dispute that has as an objective or as an object of the claim the unauthorized reuse, of a work of art, a poem, an image, then copyright is our legal framing. But if the topic is that of disinformation or deepfake, then the areas of law that regulate that type of behaviors are to be found somewhere else in the field of, depending on the specific case, media law or telecommunication law, or in certain cases areas of criminal law. And of course, this rule will operate differently because the values and the fundamental rights that they are intended to protect are different. Giving you, for example, a few additional inputs in the lines of what Mr. Turkowitz did with regard to the copyright developments in the EU and in the US. Whereas we have, as you correctly pointed out, Neil, the text and data mining exceptions in the corporate and the digital single market, and it would be interesting to see how they develop and how they are implemented, especially Article 4 with the opt-out possibility. And to get back to one of your points, Neil, sorry, what I've seen recently is the implementation of basically a modern version of the robot.txt. If you remember at the beginning of the internet area, when Google started indexing the various web pages, there was this kind of opt-out de facto option made by a small piece of text saying, "Don't index me." And there are a couple of initiatives out there that I've seen, usually by author associations, that tag their work of authorship accordingly. Obviously, for this to work, you need a scraping algorithm that respects this opt-out request, right? That a fundamental element. Otherwise, is can you please, I don't know, stop? No, okay, thank you, right? There is no a proper enforcement element there. And here I think that Article 4, so with this kind of codification, in reality is an ex ante or ex post, we could discuss it, could become an interesting model. There are some mismatches in the sense that 3 and 4 in Europe, Article 3 and Article 4 are made for text and data mining, which is not exactly the same as a generative AI. And this, I think, is another element that we have to keep in mind. They will probably apply, however, to many, confusingly, generative AI situations because their definition is very ample, right? But of course, here we end up in a situation, and here I agree completely with your point. Again, Neil, sorry, we never met. I take the liberty of calling you by first name. That a lot of the current rules are already capable, especially in the field of copyright, to address certain situations. If I ask ChatGPT to make me a perfect copy of Mickey Mouse, and I've done it recently just for the sake of having a factual confirmation, the answer is this is against my terms of use, in the sense that it's able to do that, but has learned probably that this is not a good idea to do, because it's obviously a case of copyright infringement. There is identity, striking similarity. If we want to enter into the detail, we could discuss whether there has been access, whether the original Mickey Mouse picture has been memorized in the trained model, or is simply an extremely sophisticated way of abstracting knowledge. But I would say that obviously always with the caveat that it depends on the applicable law, most of the time such a situation is already now infringing. So it's more of, and I refer to what Litz just pointed out, the issue of awareness. So we need awareness at every societal level. We need awareness also in judiciary, to understand the technical, legal, and also social implications of these models. I would be wary of expanding further copyright rules because, not everything that is under the sun has to be regulated by copyright. We need clear copyright rules that strike a fair balance between protecting the moral and economic interest of the authors, but also on the other hand, those of the public to access and those of the society at large to benefit of the technological improvements that AI can do. At the other hand, of course, we need to rules that somehow address this technological development. And I end with just one more very short point. I'm conscious of the time. Right now at the European Parliament, well, in the co-legislators, we have a complex legislative process where 3 legislators that discuss together text. There is the AI Act proposal that I'm sure many here will have heard of. And this is an attempt to regulate certain elements of AI, not from a copyright point of view, but from more of a general, I would say, public law perspective, by identifying certain AI applications that are forbidden, outright forbidden, because they are believed to be too risky. Think of social scoring, for example. A second set of AI classification that is, we could say, the core of this legislation, called high-risk AI. And in this case, a number, and we won't discuss them because we will need another whole webinar series, perhaps, a series of rules outlining the obligations of AI developers in ensuring that the AI that they develop conforms with certain standards that can be found in various areas of law. So from completeness to representativeness of the training data, in order to avoid that AI creates, for example, wrong or biased results. And then down the line in this way. Interestingly, there is a provision that has been introduced by the Parliament, but so we will not, we don't know at the moment if it will make it in the final text, that obliges foundational model developers to summarize the training data that has been used when this is copyright protected. Now, I like and I don't like this provision, and I summarize my intervention here. I like it because I think that training data have to be disclosed, but not only, certainly when, but not only when they are copyright, because together with copyright, there are other fundamental rights such as freedom of expression, pluralism, representativeness, personal data, et cetera, that need to be protected. So yes, copyright, but also these other fundamental rights needs to be reflected. And if we want to achieve that, and I again make and I promise I stop talking, you shouldn't invite academics as last speakers. We wouldn't trust the decisions of a court of justice or of a parliament if they were secret, if they were some sort of black box. We want to know the reason why that adjudication, that decision has been achieved. Why should we apply a different standard in the case of AI? Thank you.
Thank you. That was quite informative. And I'm myself a copyright and intellectual property lawyer, so it's interesting to see. One of the basics of copyright is that copyright cannot protect data per se, right? So it can protect the structuring or restructuring of data, certain databases, the way they are structured. This takes us back to our discussion with respect to, do we need new rights in the era of generative AI, and how do we go about it? And we have questions coming from the audience, and Thomas, you have already touched upon this. How do we regulate AI? How do we regulate generative AI? We know about the EU AI Act. So how do we strike a balance between fostering AI innovation and protecting the rights of creators, and not just the rights of creators, but also the members of the audience. They want to know, how do we protect privacy? How do we protect data protection? And most of you have touched upon these issues, and Neil, Thomas, if you have any other remarks in this respect, please go ahead and share them with us briefly.
Yeah, I would love to address that. I think the critical part of ensuring that copyright can't be used in training AI without authorization is the protection of personal sovereignty. And again, it comes back to fundamental notions of protecting agency and consent in a digital world in which those values are always at risk. So I think my overall sense is that if we want to have any hope of regulating AI on a very broad basis and dealing with the plethora of issues that arise as a result of AI, we need to start with the issues that are about present harm. That we can't allow these issues of future existential harm. We can't allow these kind of motion picture dystopian visions to allow us to not address the things that require no speculation. We know today that generative AI is trained without consent of creators. Establishing that has to stop gives us a foundation for dealing with all of the various other issues that threaten personal sovereignty. So I think it's important on its own, and it's important as a foundation for dealing with much broader questions of regulation of AI.
Thank you, Neil. I want to go back to Liz. Liz, going back to you, how can IP frameworks be effectively adapted or developed to balance the promotion of generative AI innovation with the preservation of, cultural heritage, local community rights, and equitable access to the benefits generated by AI generated creations?
Thank
Over
you.
to you.
So this is my analysis. When you look at the compliance of IP principles in general, we've been looking at the international conventions via WIPO, right? And when you look at also the WTO and the role that TRIPS has played, I mean, it goes without say that we definitely need an international instrument on TK, TCE's cultural heritage, right? So that then it introduces the bare minimum in terms of protection of these rights, and then also now boosting and promoting domestication of this international instrument. In my view, I would propose perhaps an incorporation of first of all, an incorporation of TK and TCE under TRIPS. That is something I think we should really look at. When you look at the how many member states have joined WTO, the compliance, we're looking at about 98%, right? So I think that would be a great place to start. Instead of struggling to maybe reinvent the wheel, it would be perhaps introducing a few new provisions under the TRIPS. And then that would subsequently help, because, looking at Kenya, for example, we have this TK Act, but it's only to extent of, the nationals, right? Because, a local legislation has no strength outside its borders. So you find that it's operating in its own cocoon, which at the end of the day is almost counterproductive. And even in that, it has a challenge for us. Kenya has about 42 official tribes. So you can imagine we could get to an extent where this could even divide us instead of bringing us together. So again, the issue of handling, internally. So there's some things I think even for us when we were passing this law, we didn't think about it. But for me as a practitioner, when a client comes to me and says, oh, but I'm from this community, why can't I use it? I have to say, it's the law, and that's it. So I think figuring out an international instrument would be the perfect thing to do. And, I think TRIPS is a place to look at compliance-wise. And then while we're hoping for this to happen, perhaps when, these trade agreements are being discussed, let's incorporate the conversation around TK and TCEs and cultural heritage, and figure out how to collaborate. How do we incorporate the issue of AI? Also, of course, in the TRIPS proposal, I mean, apart from just incorporating TK, the issue of AI and generative technology and whatnot, I think we need to have that. And so subsequently, the trade agreements we're having, be it bilateral or whatnot, they should also have those conversations. IP always tends to take a back burner until something happens, and then guys are like, oh my goodness, we didn't think about it. So I think it's time we did that, because it's also what will boost innovation, right? Because we're always talking about, oh, we're not innovating enough, we're not catching up enough, especially in the global south. People are fearful, and the more we think about it, then innovators are less fearful and more proactive in innovating and creating and putting the innovations out there and commercializing. So we really need that. I think even something else that also has to be happening is, conversations with the different embassies that we collaborate in our different countries, the conversations surrounding, with the business attaches and the collaborations as well. We need to start seeing more of the conversations around AI and TK and cultural heritage. Those are barely happening, and we need to show creatives where the money is at. Even the countries need to see where the money is at. I think that is usually just the greatest challenge, and we need to remove the IP from the back burner and bring it to the front stage, because without IP we have nothing. The economy evolves around intellectual property, period, depending, regardless of where it's from. So that would be my proposal. Thank you.
Lovely, thank you. And yes, that makes sense, really. And as we're running out of time, I would really like to quickly summarize what I heard from all of you. Now, number one, generative AI comes with legal risks, including IP infringement, content use, access to content. In many cases, it also poses legal questions that are still being resolved. For example, does a copyright apply to AI creations? Is it clear who owns the content that generative AI platforms create? Artists, number two, artists do not view AI as a challenge only. They also see it as a collaborator, a part of this new hybrid intelligence. We need to talk about AI and emerging technologies as collaborators and not just as forces to replace humans. Also, IP in the field of generative AI intersects with other legal areas such as data protection, agency, liability, and cybersecurity. Number four, through generative AI, though generative AI may be new to the market, existing laws have significant implications for its use. Now, courts are sorting out how the laws on the books should be applied, or the legislators are thinking about new laws. There are infringements and rights of the use issues, uncertainty about ownership of AI-generated works, questions about unlicensed content in training data, and whether users can prompt these tools with direct reference to other creators' copyrighted works without the permission of the creator. Now, in the case of generative AI, number five, in the case of generative AI and IP, the legal system is being asked to clarify the bounds of what a derivative work is under IP laws, and depending upon the jurisdiction, different courts may respond with different interpretations, and the outcome is expected to hinge on the interpretation of the fair use doctrine or interpretations of text and mining data mining exemptions, which allow copyrighted works to be used without the owner's permission for example, news reporting, teaching, or research. So that's number five. And number six, which is, I think, rights in alignment with UNESCO's mandate and UN mandate is balance is the key. Now, the discussions around IP rights, data protection, potential misuse of AI-generated content serve as a reminder that the development of effective and sustainable AI regulation requires a nuanced and collaborative approach. By addressing the underlying themes and issues in this discourse, governments and organizations can work together to shape a future where generative AI is used responsibly and ethically, unlocking its full potential to benefit society as a whole. And as you all mentioned, raising awareness, not just regulating, is the key in this regard. Thank you so much. Pratik, over to you now.
Thanks, Mimi, and thanks to all the panelists. It was a fascinating conversation, and I think that we've just really scratched the surface. There's much more to deep dive into each of these strands, but the point of this conversation was to bring some of these strands together. And as we continue to work on it, even including through an advanced online, massive open online course in around 2025, we'll have some of these debates settled, and we'll continue to engage with our very active community of judicial operators going forward. So thank you to all the panelists. Thanks to Mimi to Miriam for the moderation. Thanks also to my colleague Charlene Dultrumo, who has been instrumental in organizing this webinar. And I would like to invite you to come join us for the next two webinars, which will take place on the 15th of June, where we'll be talking about artificial intelligence and admissibility of AI evidence in court. And then the last one on 6th July, which is going to be on virtual reality and augmented reality, and how can judges keep up with it. So thank you so much and have a good day.